4491 of the case one.
Writ petition has been allowed. It is held that the deceased husband of the petitioner fulfilled the criteria. And pension rules have nothing to do with this. We'll go through the judgment, you'll see it.
Much of.
May I please advise? Lordship, I have a prayer for listing of a repetition as motion, Your Lordship. Matter pertains to transfer, Your Lordship.
When?
Tomorrow, Your Lordship.
All right.
May I please, your lordship, with the consent of the petitioner, I beg to mention item number 8. Lordship, may I pray to take up this matter after vacation?
Item number 8.
8, hearing matter, lordship.
All right. You are for?
I am for respondent number 3, Bongaigaon Refinery.
The learned counsel appearing for the respondent number 3 seeks adjournment of hearing of this case with a request to post the matter again after 3 weeks. Since the prayer is made with the consent of the petitioner's counsel, take it on naam to the word. Respondent number 3, Ms. R. Kakote. The counsel for the petitioner, Ms.
May
Yeah.
I please, your lordship, I
Yeah.
would beg to mention.
Who is the petitioner's counsel here? Petitioner's counsel, same stands allowed, list accordingly. Yes.
I beg to mention item number 11, Your Honor, for adjournment, Your Honor. The senior counsel is having some personal difficulty.
You are for petitioner or on the prayer of learned counsel for the petitioner, this hearing of this matter stands adjourned for 4 weeks, list accordingly. Yes.
My lord, there is a hearing matter, my lord,
Item number?
14.
Yes. Do it later.
My lord.
On the request of learned counsel for both the sides, hearing of this matter stands adjourned for 3 weeks, list accordingly.
Keep your place.
No, tell Mikhail to check corrections, and then after I come, they'll make it on.
This for more than item 7.
The petition against the rejection of my representation against my transfer order. Initially, when the petitioner had approached this honorable court, this honorable court had passed an order whereby the respondents were required to look into my representation and pass necessary orders thereon.
Where is the transfer order, page number?
Under that order, transfer order, lordship would find at page 23, my lord.
Page 23.
My lord. The actual order is at page 23A and 24.
So you are
They were
transferred from Duliajan to Delhi.
Delhi, my lord.
What is the problem?
To Delhi and to Delhi. Now, my lord, if lordship has page 26 for a moment, their transfer policy, my lord, which says that after a certain tenure having been completed, I am entitled to be given a choice amongst others for a home sector. I've got 4 years of service left. That home sector option was never given to me, and while rejecting my representation now, they have put me on the 3rd tenure, whereas I should have been considered under the 4th tenure. If they consider me under the 4th tenure clause and they have to reject me, then it's another matter, and then it's administrative exigency. But rejecting me on the 3rd clause when I should have been considered under the 4th clause.
Consider for 4th clause and reject it now.
Lordship, may kindly come.
What is the problem in going to Delhi?
So my wife has had a neck operation and I need to be here with her.
People don't want to go out, huh?
My lord,
How long have you spent in Assam?
my lord, in
In
Assam,
home sector, he has been 20 years, Lordship.
but outside home sector, it is 14 and 11 years, and I have never taken a choice. It was there, it was at there
Delhi-
that I am here.
Delhi is not a bad place to
My
go.
lord, perhaps, but
Better treatment.
leaving my wife and my lord, it
Take her.
cannot be, my lord. I have given the photograph. She's buried. Cannot be. That is the only,
What do you have to say on that? Wife cannot travel?
page 64 is the photograph.
Huh?
Only photograph, nothing has been, no medical.
No, then you go and see, visit his home and see.
And Lordship, can you see, the Delhi is one of his choice posting, Lordship.
No, that was because I
imp-
was not given a home choice posting option,
Page-
option at all.
Lordship, can
When
you
I should
come,
have been given it. Had I been given the choice, I would have opted for a home sector.
page 45, Lordship.
The software did not allow me to put in the home sector. Could I do?
No, see,
That was
Mr.
my initial-
Majumdar, you cannot insist that you should be posted all along.
What I'm saying is that
Hmm.
when they reject my representation based on the policy, then the correct clause of the policy they refer to,
Hmm.
I be given the choice. They cannot give it to me on administrative.
So that is your only grievance.
that is what I can
Change
find.
the reference of the policy.
Lordship, Delhi is one of his choice, Lordship.
That was
Page 45, point number 10, Lordship.
No, but is it a fact that his wife cannot go to Delhi?
That
is that a-
aspect is, that aspect, I can't say that right now, Lordship.
there's a neck operation and she's not allowed to travel or move around.
Where is the
Neck has been
doctor's
cut.
certificate? When was the operation?
Page 64.
Operation took place when?
Malad,
When was the operation held?
Malad, that was done in 2025. Malad, the medical reports are there. She underwent the operation in 2025.
No, that's correct, but operation 2025 in January.
Malad, April. April.
So after some time there is a healing process, and then why she would not be able to travel to Delhi? For all times, next 4 years she won't be able to travel to Delhi.
They've issued a movement order where I have to move now, my dear. That aspect has never been looked into.
But where is the medical certificate? That
Lordship will find a page 66 and all.
page?
From page 64 is the photograph, then page 65 onwards are the medical documents.
No, photograph is fine. She has undergone a
Madam.
surgery. But that cannot be a ground to stall the process. You have to show where is the medical certificate which says that she cannot move to Delhi by air.
That,
Your client is entitled to travel by air or by train.
by tree.
By train. Air conditioned coach. AC coach.
Assistant Sub Inspector,
Yes.
he'll be getting, Lordship.
Why she cannot travel to Delhi by AC coach? If there is something or some medical document, you show us.
That I have-
Otherwise,
Is
in
this
transfer
documents-
matters, how the court is expected to interfere in this manner?
Ma-
Every transfer is inconvenient for someone or other, and everybody has to undergo transfer, is it not? So
Like,
transfers
Lordship,
do
looking at
happen.
the transfer policy for no matter why the person would have perhaps some say to have them reconsider the issue when they have done it on a
Mr.
wrong premise.
Majumdar,
On the wrong premise, it has been done. If Lordship would kindly
these
say.
grounds are not
Because
strong enough.
the policy, I cannot claim a right under the policy that it should be done like this. But when my rejection is under the specific clause of a policy, and they profess to have followed the policy,
Hmm.
only prayer is, my lord, if they follow the policy, the clause which I am entitled to.
So these are very, very trivial issues.
Well,
You change it, refer to clause 4 and reject his application. That's all. Do
It's
it.
very reason order, Lordship. Speaking order, Lordship. can you say-
That clause which is the reason, the very reason of this.
I'll give you 7 days time to produce a medical document that your wife cannot travel to Delhi by train
My lord.
for next 4 years. If you can give it,
4
fine.
years would be-
Otherwise, pack your bags.
4 years. would be-
These ideas of not moving out of home should now come to
But
an
I
end.
have already served the required out of home sector posting as required by.
But you have served 20 years in your home station also.
Not my home station, it's in the sector.
Home
The sector-
state. Home state. You have served.
Sector, my lord. They include a lot of states in the sector. It is not the state, it is not the posting at Duliajan that I am seeking. It is a posting in the home sector which requires to be considered under their policy is the only payment.
We'll examine it. You go and join in Delhi. We'll examine it. Except for a medical document, I'm not
Lordship, the
interested.
chart will say, Lordship, he was at Jorhat, Bongaigaon, Nazira, Guwahati, Nazira, again Duliajan. All this year, he has been 20 years, Lordship.
The tenures, my lord, when I have stayed, Lordship will also see, from 2001, 2005 to 2009.
97, from 97, Lordship.
34 years of my service. At the fag end, I'm asking for one.
I'm not
choice which
inclined
I'm
to
entitled
stay.
to another.
What do you want to do? You tell me. I'm not inclined to pass any stay order. It's not a
So
case
you
of
look
stay.
at page 27 and then reject it, my lord, then fine.
Then I'll deliver a judgment. You want it, then you argue full length, I'll deliver a judgment. These are not matters the courts will interfere in transfer. Very
Otherwise,
trivial.
sir, I was not pressing that the policy needs to be followed by them. in any and all cases. Under orders of this honorable
You
court, I
have
reject
four, you have 4 years service left.
3 years, 10 months, my lord. I
Then
get one
that's
tenure.
almost
I would
4
get-
years.
I would get one tenure.
And then you expect the court to pass an order that till next 3 years, 10 months, you cannot be
No,
shifted.
no. What I was saying is,
Hmm.
let them consider it under the proper clause. They cannot do it in administrative excellency when I am a serving and either I go for either I give up my job or I go. That would be a separate issue on the decision of the petitioner. But if they are considering it and rejecting it, not
No,
referring to
Mr.
the proper-
Majumdar, you are not answering the question
My
of the
lord.
court.
No, 3
If
years,
it is a medically backed stand
my lord.
that your wife cannot travel to Delhi,
True.
we will look at it from another
I
perspective.
understand.
Then we'll bring it out from the ambit of transfer orders and look it in from the prism of Article 21.
And
That if your transfer deteriorates the life of your wife, which endangers her normal living, we'll look it through the prism of Article 21. But for that, you have to give us material.
that
This policy, that policy, we'll hear it in due course. No question of stay. You are in service. It's a transferable job. You have to undergo transfer. Some cosmetic reasons here and there, you expect the courts to interfere. That's not going to be possible. Make up your mind. What do you want? Next week or judgment today? You need 5 minutes to decide. Call after 5 minutes. Yes.
obliged.
No, these are according to us, these are all covered matters, my lord. After I concluded my argument, my learned friend took time on 2 occasions. Now it is for him to make his submission. As you would recollect, these are all persons who were engaged on contractual basis and they were terminated without any proper inquiry. And my lord, your lordships, not only.
No show cause notice was served
No,
upon
no.
them.
Even if show cause notice was issued, my lord, there are judgments of this honorable court. You have to follow at least a minimum procedure, merely because the show cause notice and then, a reply and a impugn order. That is not this scheme of things.
Hmm.
Now, there are series of judgments, my lord. My lord, there are 3 coordinate bench decisions of this honorable court
Hmm.
where
Let's see
it
the
was said that
judgments of them.
they would be in deemed suspension. They should follow the procedure akin to 311.
The next item in this series.
Yes. If your lordship should kindly have the judgment, my lord, last time I.
So let us, Mr. Chaudhary, this matter was heard some time back.
Yes, yes.
Just to recapitulate.
Yes.
What are the facts of this
Yes.
case?
Now, if your lordship would kindly come to page number,
You're referring to WPC?
Mohesh Jyoti Deka, 4707. Manas Jyoti.
Manas. Okay, 4707.
Yes. Now, if your lordship should kindly come to page number 26,
Hmm.
that is the show cause. In persons of office order white dated so and so, Ranjit Goswami, ADC of this commissionerate, has submitted inquiry report in connection with alleged anomalies and involvement in various irregularities, such as violation of guidelines of PMAGY and 14 Finance Commission on so and so GP under Lahorigarh Development Block, Morigaon. On perusal of the report, it has come to the notice of the undersigned that while you were serving as Gaon Panchayat coordinator, Lahorigarh Development Block, you have done deviation in case of PMAYZ houses, geotagging of the same beneficiaries' houses in different multiple locations in various stages of level inspection, which indicates malafide intention. In view of the above, you are asked to submit your explanation along with all the relevant documents, if any, as to why you shall not be terminated as per the terms and conditions laid down in contractual agreement, which amounts to gross indiscipline as well as gross negligence of duty and misconduct on your part. My lord, we were not associated with this so-called inquiry conducted by Ranjit Goswami. So this was done behind our back. Now my reply is at page 27.
Yes.
In this regard, I, Manoj Jyoti Deka, humbly inform you that I have been serving as PC since 5/1/15 to 39/21 in Boralimari GP and 1/1/10/21 till date in Borsola GP, and have been serving in two Gaon Panchayat to the best of the interest. Sir, when I joined Borsola GP, I was not aware about the area of GP of NPK. So I have taken help from ward members and GP secretary of the official work, particularly for PMAYG house inspection and geotagging purpose. Sir, we have done the PMAYG house registration and geotagging as per office order dated so and so of the secretary so and so, depending on target of so and so, which was 1800 approximately. I inform you that I have not done any geotagging against the beneficiary where the complaint arise and was done by other GP official. Sir, I have done geotagging of PMJ beneficiaries with the help and presence of ward member of that particular ward for identity of the beneficiary. So this was the explanation. Then the final order is at page 28. In pursuance of the office order dated so and so, the inquiry officer has submitted inquiry report wherein Manoj Jyoti Deka of so and so was found involved in various irregularities such as violation of PMAYZ and 14 finance. Whereas a show cause notice has been served by this office order dated so and so. And on the basis of the inquiry report submitted by the inquiry officer against Manoj Jyoti Deka, Gaon Panchayat coordinator of Borsola, under GP under Lahori Ghat Development Block of Morigaon Jilla Parishad. Whereas the reply to the show cause notice is submitted on 15/11/22 by C. Deka is not found satisfactory. In view of the above and in pursuance of clause 9 of the contract agreement, Sri Manoj Jyoti Deka, coordinator under so is hereby terminated with immediate effect. Now, my lord will kindly see the clause 9 is at page number 23. Page 22, my lord, sorry. Clause 9 speaks of remuneration. A remuneration contractual employee will be fixed paid so and so. Page 22, towards the bottom, remuneration. So it has got nothing to do with termination. Now, my lord, the state has filed an affidavit where they have annexed a copy of the model agreement form, which your lordships will find at page 51. I never signed this agreement, my lord. Let them show that I signed this agreement. Page 51.
Yes.
The employer shall reserve the right to terminate the contractual agreement at any point of time if it is found that services rendered by the employee is not satisfactory, or if it is found that any declaration of information furnished by her or him proves to be false or willfully suppressed, or if there is any breach of any of the terms and conditions of this contract, or if the employee is found to be involved in any act of indiscipline, misconduct, or if the employer is found to be involved in any act that may become embarrassing to the employer. The employer may at his option pay 1 month's salary in lieu of notice, but nothing in these terms and conditions of employment shall prevent employer from terminating the employer's employment without notice or payment in lieu of the appropriate circumstances. In case of the employee shall give the employer minimum 13 days of his time. So, my lord, this is a model agreement which they say, but I never executed this agreement. The agreement which I executed, my lord, their clause 9 pertains to the remuneration part. Now, my lord, there is a 2-3 judgments on this point, my lord. Last occasion I have placed it. I think it must be on the record.
Yes.
First, if your lordships would have WPC number 104 of 22. Has been good, আছে না?
Oh, yes, yes.
Yes. the lordship is holding that, please come to para 9.
Just a minute, let me organize the. These are the three judgments. এটা আছে অলপমান।
In fact,
Chaudhary, just have a look.
Yes.
These are the judgments. এইটোত আছে নেকি আৰু judgment আছে নেকি?
Huh?
Check here.
these are the ones which I placed, but
Hmm.
there are other judgments also.
Let me see if it is in the other file.
I think in the second file it may be there, Miller. Second file it's up.
Do you have another copy of that?
I'm handing over that.
ইয়াত গাঁঠি থোৱা আছে নেকি বেলেগ judgment? নাই।
Same facts, Miller. Please have a look from para 15 onwards. তোমার কপি গুলা দিছিলো।
Yes.
So, my lord, another judgment, please have a look, my lord, relying on Purushottam Lal Dhingra, there are 19 onwards.
Yes.
Yes.
Sure. এই দুটো দি দিয়ক। এইটো ঘূৰাই দি দিয়ক।
If some allegations are taken note of, my lord,
Hmm.
then Supreme Court says I am entitled to protection under 311. If I am guilty of misconduct, then a regular inquiry is a must. That is what was relied upon in this case. And accordingly, my lord, at para 21 of this WPC 4266 of 23,
Hmm.
accordingly, court is inclined to hold that termination order dated 13th of July passed by the Commissioner PNRD, same department, terminating the service of the petitioner is not sustainable in the eyes of law, and the same is liable to be set aside and quashed.
Yes. এইটো judgment এটা copy এটা কৰি ল'ব।
Yes, yes.
We'll need this judgment. I think
Yes,
it's not maintained properly. Yes, then next.
this is the judgment, my lord, and the other first one also I'm giving. It will look.
এইটো এটা copy কৰাই লওক। Copy এটা কৰাই পেলাই দি দিয়ক ঘূৰাই, photocopy কৰি। Hmm. Yes, which is the
Yes.
other judgment?
Yes. Now, my lord, there is a recent judgment of the Supreme Court.
Hmm.
Allah. That is 2024 SCC online SC 2282. Well, that is, I think last time I have given an unreported copy. UP State Road Transport Corporation versus Brijesh Kumar. Para 19.
Yes.
Has your lordship got it?
Yes.
Please come to para 19. The services of the respondent have been determined solely on the ground of misconduct as alleged, but without holding any regular inquiry or affording any opportunity of hearing to him. Termination order has been passed based on some report which probably was not even supplied to the respondent. No show cause notice appeared to have been issued to the respondent. Therefore, the order of termination of his service, even if on contractual basis, has been passed on account of alleged misconduct without following the principles of natural justice. Termination order is apparently stigmatic in nature, which could not have been passed without following the principles of natural justice. In fact, my lord, when it comes to confirmation of a provisional, at the stage of whether he should be retained or not, if at that stage certain misconducts are taken note of and his services is not extended, that's a different thing. But you are terminating my service here, taking note of some misconduct. So even if Article 311 per se may not be applicable, but principles of natural justice is definitely applicable. So that is the case, my lord. And your lordship has also passed as 2 orders, my lord. I think last time I placed it. Yes. Your lordship judgment is Sujit Burman versus State of Assam. WPC number 1785 of 22. Date of order is 1623.
Do you have an extra copy?
No, I'll give my. WPC 1785 of 22.
Okay, what has been held?
Surojit Burman versus State of Assam.
What has been held there?
Yes. The court finds that in terms of the contractual employment of the petitioner as computer assistant, clause 2 of the said term provides that contract may also be terminated without assigning any reason before the contract period by either of the parties, subject to giving 1 month's advance notice to the other party. Moreover, as indicated in clause 11 of the agreement, in view of arrest of the petitioner in connection with the CID case number so and so, it cannot be said that conduct of the petitioner could not have been found to be embarrassing by the responding authorities. As the service of the petitioner is terminable by giving 1 month's notice, court finds that petitioner is disentitled to the relief of his contractual service being restored in view of provisions of section 14D of the Specific Relief Act, which provides inter alia that a contract which is in the nature terminable in terminable in nature, which are not practically enforced. No, I'm sorry, this is not the case.
You are reading some of the judgment.
No, this is Jan Soikia, which is in Act. I'm sorry, Miller. Your lordship judgment. Writ petition. Oh, it is in the annex in the writ petition, Miller. That is the only judgment, but the same honorable single judge has passed that order in the other case, relying upon Purushottam Lal Dhingra. Yes, I'm page, my lord, will kindly come to page 34 of the writ petition. Somewhere in the middle, the sentence starting with the order of termination. As a lordship got it. Page 34 of the writ petition.
I think it will be page 38, not 34.
Oh, Sofiqul Islam Police. I'm sorry. Yes. Please come to page number 38. Lord. It is no doubt correct that in case of contractual engagement, the terms and conditions of contract would govern by the service conditions of the employee. In the present case, a contract agreement is signed by the petitioner does not have a clause permitting termination of a contract at any point of time if the services rendered by the contractual staff was not found to be satisfactory. However, what is to be noted herein, that bare perusal of the impugned order of termination demonstrates on the face of the record that the same was issued on the basis of findings of inquiry proceeding conducted behind the back of the petitioner, wherein it has been projected that the petitioner was guilty of misconduct. Therefore, the order of termination of service of the petitioner is not only based on allegation of misconduct, but is also stigmatic on the face of the records. In other words, the impugned order of termination was founded on allegation of misconduct. However, the petitioner is not given an opportunity of being heard in the matter. Therefore, it is clearly a case where respondents have acted in violation of the principles of natural justice. The order of termination from service issued to the petitioner has the trappings of an order of dismissal, removal from service. Therefore, such an order could not have been issued without giving employee an opportunity of being heard, even if the same pertains to temporary or contractual employee. This is for the simple reason that such action, besides causing serious prejudice to the interest of the employee, would also have bearing on the prospects of his future employment. Situated thus, this court is of the unhesitant opinion that order of termination dated is unsustainably unfair law. Therefore, same is liable to be set aside. So consistently, my lord, there is only one aberration, that is Jan Soikia's case, where we have already filed an appeal. Appeal is pending. And the same honorable single judge, my lord, in the other case, as I have already submitted, my lord, that is WP, the other judgment which I placed, my lord, there it has taken the view that relying upon Purushottam Lal Dhingra, that it could not have been done. Back. There are similar judgments on the same line. Therefore, my humble submission is, my lord, these are all covered cases. So this repetition should be allowed. And as has been observed by the later two judgments, my lord, they should be deemed to be in suspension and they should proceed.
All right, now let us assume that the court accepts and agrees with your submission. According to you, what would be the course of action from now onwards?
So they'll hold a regular inquiry, they'll prove the charges, thereafter get rid of me.
Regular inquiry as per which law?
As for the minimum, that minimum has necessarily need not be, Assam Services, the discipline and appeal rules. That is, an inquiry officer should be appointed where I should give it an opportunity.
Okay, now why it should not be as per the rules of 1964? Can you have
Can
the
be, it can be,
1964
it can be also.
rules
Huh?
of 1964? Assam Service Discipline and Appeal Rules.
I think in one of the judgment, this honorable court has said that it should be as per.
I think there is a judgment authored by this court.
In Imran Hussain, like,
Where is that judgment?
yes, I'm handing over. I
Because
think,
section 2E of this rules
yes.
includes even a temporary person as a government servant.
In fact, my lord, that government press versus.
Please see the definition in rule 2E. Mr. Datta,
Yes, yes,
you will have to also respond to 2E.
yes, yes. Government servant means a person who is a member of a service or who holds a civil post in connection with the affairs of the state, and includes any person whose services are temporarily placed at the disposal of the central or state government or a local or other authority, and also any person in service of the state or central government or local. I'm obliged. Yes, this will
So
cover.
why the procedure prescribed under rules of 1964 should not be followed even in their case? Is there any reason? Mr. Datta, that's the point here. Because termination is a major penalty. You are issuing the order of termination as a penal measure
Hmm.
on the ground that they are involved in misconduct.
My lord.
Fine, it may be correct, you may be right.
2011.
But the question here is
16.
why you have not followed the procedure laid down in 1964.
6 SCC 15.
I'll sir, look over it.
Do I have to- My lord, yesterday while going through, I could lay my hands to two more judgments of the Supreme Court, where even in contractual matters, in view of scatina of judgments of the Supreme Court, now courts are examining. Merely because an employment is contractual, it does not mean that they will not get the constitutional protection. It doesn't say Article 311, but principles akin to 311. It's perhaps the only exception would be if somebody says, now we are no longer engaging you because there is no more job, because it was contingent upon completion of the job. Those are exceptions. Otherwise, the moment you take note of an allegation, then you must give me an opportunity. That follows right from Amin Milord Purushottam Lal Singhra till date. So here is a case they have taken note of allegation. The moment you took note of allegation, and your lordship has also held that these are stigmatic in the judgment I have read. So, my lord,
Where is the judgment in a similar matter? I remember
It is-
it was observed that
number two, item number two, one. Now they are filed to.
Kuntu judgment. Can you take up Mr. Chaudhary? Can you
Yes,
take
no,
this one?
next to the.
No, we'll take it out from the system.
Yes, yes.
Yes.
It is
We'll take
4266 of 23 WPC.
1 minute. 422
4266 of 23.
4266. There is some observation regarding it was not fully developed, but some observation I remember
Yes,
was
yes.
there.
It does not strictly refer to Milord 2A, but it refers to rules. It is too well settled that even in case of a temporary appointment, principles of natural justice cannot be altogether abandoned. In the present case in hand, nature of accusation against the petitioner is stigmatic, as there is a specific allegation against the petitioner of gross negligence of duty and misappropriation of government money with malafide intention which appears from the show cause notice to the petitioner. It would have been a different matter if the authorities have chosen not to renew the contract. That's the exception, Miller. However, in this case, Commissioner had issued a show cause notice which contains stigmatic allegation against the petitioner. Providing of inquiry report to petitioner is in the considered opinion of court is not sufficient. In our case, here it was given. In our case, it is not even given. Compliance of the principles of natural justice. Impugn order of termination does not disclose that the petitioner was permitted to participate in inquiry. The order of termination,
Which para you are reading from?
para 15 minutes. It is too well settled that even in case of temporary appointment, the principles of natural justice cannot be altogether abandoned. In the present case in hand, nature of accusation against the petitioner is stigmatic, as there is a specific allegation against the petitioner of gross negligence of duty and misappropriation of government money with malafide intention which appears from the show cause notice to the petitioner dated 6/5/23. It would have been a different matter if the authorities would have chosen not to renew the contract. However, in this case, Commissioner and PNRD department had issued a show cause notice to the petitioner which contains stigmatic allegation against the petitioner. Providing of inquiry report to the petitioner in the considered opinion of the court is not sufficient. Compliance of the principles of natural justice. The impugn order of termination does not disclose that the petitioner was permitted to participate in the inquiry. The order of termination also does not disclose that inquiry was conducted in presence of the petitioner. Hence, the court does not find any reason to call for the records because presumption that the petitioner did not participate during the inquiry could not be successfully repelled by the respondent. There is another aspect to the issue. If delinquent is allowed to participate during inquiry process, which is accepted to be due compliance of the principles of natural justice, there is no requirement at all to have a proceeding drawn up against him as envisaged under Rule 9 of the 1964 rules. And inquiry is only to enable disciplinary authority to arrive at a satisfaction that the delinquent employee has committed certain act of indiscipline, which should have enabled the authorities to draw up a departmental disciplinary proceeding against him. If an inquiry is conducted which is precursor to departmental proceeding, yet the departmental proceeding is initiated, authorities are required to comply with the requirement of Rule 9. So indirectly, my lord, court has covered 2E.
Yeah, but the learned judge says there is no requirement to hold an inquiry under Rule 9. But this
I-
is not the judgment. I am referring to another
is
judgment where the
If-
court has
if-
said that
No, my lord, I think what the court, with all respect, my lord, what court was of the view that a preliminary inquiry which is constituted to find out facts, whether one should go for DP, in that case, one need not be, associated with. That is very clear, my lord. That Supreme Court has, settled that long back. But the moment, but I am on a different tangent, man. My submission is, you are taking note of an allegation of misconduct. The moment you take note of an allegation of misconduct, then I am entitled to an inquiry. A hearing not merely a show cause, a proper inquiry. May not be strictly in consonance with Rule 9. At least there somebody should be appointed as an inquiry officer. Then it will comply with the principles of natural justice. End of the day, what Article 14 requires? A fair procedure. What is a fair procedure? Wherein a person gets an opportunity to defend his case, may not be strictly in terms of Rule 9, but if he gets an opportunity, if it inspires the confidence of the court, end of the matter. But when nothing is done,
and why Rule 9 should not be invoked here?
no, I don't think so. That's correct. The moment 2E includes a temporary employee, Rule 9 will automatically come into play.
So that's what I'm saying.
Yes,
Rule 9 will have to be invoked here if
has
it is
to
a
be ready to
termination.
it.
Hmm.
Recently,
Can you find out that judgment? I think it is 3-4
I think
months back.
last occasion Mutan আসছিলে একটু। Just give me 1 minute time. এই যে এটা যে rule 2A এর implication টু। কৃষ্ণকান্ত হ্যান্ডিক নেই। হ্যাঁ?
Before rule convert.
Huh? Oh, no. I think, my lord, on last occasion, this issue did crop up. I don't think I referred any judgment on that. But this. Nine, that a rule 9 apply operably. My lord, there are two judgments of the Supreme Court, my lord. One will you paribo niki? 2021 6 SCC 15. Paribo. Acha.
You can give the citations.
Yeah, I'm giving, my lord. 2020, my lord, 2020, kundu. Itu kundu. I think, my lord, the same judgment which we are reading, para 22, please come to para 22.
Hmm. You are referring to Imran Hussain.
Yes, para 22.
Hmm.
The respondents are directed to reinstate the petitioner in service forthwith within a period of 15 days from the date of receipt of the certified copy of this order. Upon reinstatement, it would be the respondent authorities to proceed against the petitioner in accordance with law by serving proper notice indicating specific charges brought against the petitioner. In doing so, it would be open to the respondent authorities to place the petitioner under suspension pending trial of or conclusion of the departmental proceeding if so advised. However, upon suspension, petitioner will be entitled to subsistence allowance. Respondent authorities are directed to strictly comply with the requirement of the provisions of rules of 64 as well as principles of natural justice. On completion of such inquiry, it would be open to the competent authority to pass such appropriate order as may be deemed appropriate. My lord,
Yes.
I'll rely on two judgments, my lord. I'm having the copy.
Mhm.
I do have some. Yeah.
Mr. Chaudhary, this is taking the matter to a very interesting
Yes.
point. I just hope I can deliver the judgment. I hope.
My lord will
I'm not
kindly
sure.
come to me, lord. Para 38 of the judgment, 2011-15 SCC 16.
Mm. Para 33.
Para 38.
So it's written 33. Yes.
A conspectus of the pronouncement of this court and development of law over the past few decades thus show that there has been a notable shift from the settled legal position,
No, just a
stated
minute.
legal position,
You're referring to 2011 5 SCC.
15 SCC Miller. The Gridco Limited.
No, where is the judgment?
Huh? भूल गई।
This is not here.
Gridco's judgment is not there, Miller.
No. I've got Tantia construction.
No, I'm sorry. No, it was. I think Lordship can have my copy, Miller.
No, you read.
Yes. Para 38, Miller.
Hmm.
A conspectus of pronouncement of this court and the development of law over the past few decades thus show that there has been a notable shift from the stated legal position settled in the earlier decision that termination of a contractual employee in accordance with the terms of the contract was permissible. An employee could claim no protection against such termination even when one of the contracting parties happened to be the state. Remedy for a breach of a contractual condition was also by way of civil action for damages compensation. That was the earlier thinking. With the development of law relating to judicial review of administrative actions, a writ court can now examine the validity of a termination order passed by the public authority. It is no longer open to the authority passing the order to argue that its action being in the realm of contract is not open to judicial review. Then, my lord, this has been followed in the other judgment which I have given, my lord. 2021 6 SCC, para 50, page 15.
Yes.
I think I have given the relevant copies, my lord.
Yes.
My lord will kindly come to para 65. 66. Oh, no, yes. Para 66.
Yes.
Even though there is an arbitration clause, the petitioner herein has not opposed the writ petition on the ground of existence of an arbitration clause. There is no whisper of any arbitration agreement in the counter affidavit filed on behalf of the respondent to the writ petition. In any case, existence of an arbitration clause does not debar the court from entertaining a writ petition. It is well settled that availability of an alternative remedy does not prohibit the High Court from entertaining a writ petition in an appropriate case. The High Court may entertain a writ petition notwithstanding the availability of alternative remedy. Then my lord will kindly come to para 69. It is now well settled by plethora of decisions of this court that relief under 226 of India can be granted in case arising out of contract. So, my lord, now these are no longer an argument that there is an arbitration clause or the contractual clause will determine the rights and obligations of the parties. These are no longer, my lord, available because end of the day, the law has changed. The earlier thought process has changed and now a judicial review is permissible.
The judgment is in Minal Country Sarkar.
Okay. Huh? Oh. Edu ki case. Telugu file good idea. That like it. Huh? Mineral country to আছে নেকি? Huh? Court. হয়তো পোৱা নাই? Huh?
Part of protein. Rajit Burman.
নাই 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 মই জানো
Partha Pratim sai kya?
Yes.
Partha Pratim.
দাম I think, my lord, while rendering the judgment in Surojit Burman, lordships relied on Parthopratim.
Yes.
Protein to substitute.
The Partha Pratim is recent. It is
Oh.
February 2025. Anyways,
My lord, on last occasion, I placed the judgment in 79(1) SCC. Please have a look at that, my lord. It has got another important aspect. Because what Article 16 guarantees not only entry into service, even thereafter. Please come to that petition. That is 1979(1) SCC 477. Paragraph 19, my lord. It is, has a lordship got it?
yes.
Para 19. It is now well settled that the expression matters relating to employment used in Article 16(1) is not confined to initial matters prior to the act of employment, but comprehends all matters in relation to employment, both prior and subsequent to the employment, which are incidental to employment and form part of the terms and conditions of such employment, such as provision as to salary, increment, leave, gratuity, pension, age of superannuation, promotion, and even termination of employment. It is further well settled that Article 14, 15(1) and 16(1) form part of the same constitutional court of guarantee and supplement each other. So not that only, my lord, when a person seeks employment, that he will get the protection of Article 16. It will extend to, my lord, even termination also. So that equality, would be available even at the stage of termination. This was again a case in the context of right of a temporary government servant. A very famous case. Eliappa.
Yes.
So that being the position, my lord, my humble submission is, I think lordship would like to dispose of these matters in terms of the.
So
earlier
in
matters-
all the cases, there are allegations of
Yeah,
misconduct.
all are allegations.
And in all the cases, show cause was,
Only so cause, and in the inquiry, they were not associated. It's so-called inquiry. All right, if that inquiry was to gather facts, then you should have issued a regular show cause, then it's okay. But you are using those, even those judgments I have also brought, my lord, when a report of an inquiry, preliminary inquiry can be relied upon, when it cannot.
so you are saying that since you have conducted an inquiry to establish the misconduct,
Exactly.
you should have allowed the employee to participate.
Yes.
There was no legal justification not to
No.
allow that.
Otherwise, my lord, you have taken a decision unilaterally. I have not been given any opportunity. The show cause notice is neither here nor there. That is my.
So this is common in all the cases.
Yes.
All
It's a
8 cases.
common thread in all the cases. In fact, we have made a chart, my lord.
Yes, I think it is
Huh.
there.
হ্যাঁ, আমি বলাই
I think this is the chart. This,
আছে
there are total 7 cases, is it?
হাই এই লো বাবা এখানে না
Yes. Yes, Mr. Datta. Mr. Datta. Hmm.
My lord, although 7 cases are annexed, my lord, the facts are not exactly same. I want to first, lordship may take the item number 1.
Lordship's kind permission can I take leave?
Hmm. Yes.
In this case, my lord, the petitioner was part of that earlier inquiry, my lord, and that inquiry was conducted as per Honorable Court's High Court's order, my lord, in WPC into writ petitions, my lord. Thereafter, my lord, the petitioner was part of that inquiry, and after that inquiry, what petitioner submitted, my lord, that is there, my lord. Lordship may kindly come to first page number 55.
So there was recording of evidence.
They have in the preliminary inquiry, my lord.
No, Mr. Datta, you must understand what the court is asking.
My lord.
The issue here is hinging on 2 important questions,
Yes,
and the judgment will be on these 2 questions and
My lord.
nothing else.
my lord.
They were engaged as contractual employees. The terms and conditions of the contract which they signed, clause 9 has nothing to do with this.
Yes,
That will clarify.
yes,
Even if you want to press the contractual terms, it will be with regard to that contract which the parties have signed, not one which is a model contract.
yes,
That
yes.
is out
Yes,
immediately.
yes, yes.
But your action is based on clause 9 of the model contract, which was never signed by the petitioner.
Yes,
that you agree.
that part I will.
But let us
Some-
forget that.
Yes,
If it is that your service is valid till say 31st of or 30th of May, and you say that from 1st of June, we don't want you. There is no need to hold any inquiry, no
My lord.
question of violation of principles of
my lord,
management.
my lord.
But even in case of a contractual employee, if you are saying that, look here, during the tenure of your service, you have done these acts,
Yes,
which amounts to some form of misconduct.
my lord.
So show cause is issued and give your reply. Reply comes and you terminate.
Yes,
Difficult.
my lord. For that, my lord, his reply may be seen, my lord. What?
Even if we
he
accept.
admitted, my lord.
Huh?
Admitted. Petitioner admitted,
No,
my lord.
misconduct he did not admit.
My lord, lordship may kindly see
Yes, yes, so.
page 58. Kindly see, my lord.
Page 50 out of which
Page 50, first item number 1.
you give the name of the party.
My lord, Syed Masood Mazumdar.
Page 58.
Page 57 is the, my lord, his reply.
Hmm.
Page 58, from page 57.3, I'm reading, my lord.
Hmm.
That, sir, after my joining, did and video so-and-so Sonai development block, Sri so-and-so showed me the so-and-so scheme, list signed by himself, and then he ordered me to prepare estimates of the schemes as soon as possible. As the schemes were already uploaded in MIS secure online portal, and he further ordered me to forward the estimates to his login ID, videos portal. I have done the same after getting his strict instruction regarding the matter. Point 4, that sir, after seeing the video signature on the 53 numbers INRRM scheme list and on seeing the said schemes were uploaded by the block level officials in online secure portal for preparing online estimate, and on getting the order of the deed and BDO, I prepared the estimate accordingly. It may be mentioned here that after estimate, the BDO forwarded the same schemes for technical and administration approval. And paragraph number C, my lord, last line, my lord. I put my signature on good faith. I have no knowledge of cancellation of ZPDP approved schemes. Those schemes were already cancelled, my lord.
So according to you, this is an admission of guilt of misconduct.
Yes, my lord.
All right, you proceed with the next argument.
My lord, yes, yes.
Mm.
That may be my submissions may be
Mm,
point
mm,
noted, my lord. And my lordship was the applicability of the Assam Service Discipline and Appeal Rules, my lord.
Mm.
Lordship, I am very obliged, my lord. Lordship had pointed out the clause 2E. But I want to read the application of the act, my lord, which is in Rule 3. Rule 3 says, my lord, these rules shall apply to all government servants except, exceptions is there, my lord, A, person in casual employment, B, person for whose appointment and other matters covered by these rules special provisions are made by the under the law for the time being in force or in any agreement in regard to the matters covered by such law of such agreement. And these cases are purely, my lord, the contractual employees, my lord.
So then tell us, then you have to hold an inquiry.
My lord, for that, my lord, I will place authorities, my lord. I have prepared some judgments also, my lord. Our High Court also and Apex Courts also judgments are there, my lord. Whether full inquiry is required or not, my lord. Lordship, may
1 minute, 1 minute.
Listen. I'm just reading my judgments, my lord. Yes, my lord. First, my lord, I want to read paragraph 14 of the Ravindra Kumar Roy, my lord, versus State of Assam and others. Lordship have my list of citations, my lord. Citation 2014 SCC Online, Guwahati 559. এইখন যে দিছিলো I have extract the relevant paragraphs, my lord, in my list of citations, my lord.
Yes, I get this citation and bring it. Yes.
Yes, first page, my lord.
Hmm.
Yes, I'm reading. This is the our Guwahati High Court order, my lord. Our High Court order.
Hmm.
Para 14, my lord. In view of the above discussions, it becomes explicit that the termination of the petitioner was not an arbitrary act without adhering to the principles of natural justice. So cause notice was issued to the petitioner and he did submit his explanation. In our case also, submission was there, my lord. Contents of the explanation fully justify the order of termination. It is to be seen that the nature of enquiry that is required to be done in respect of civil servants and Article 311 of the Constitution need not necessarily be adhered to the contractual employees. However, the contractual employees are not governed by service rules. They are governed by the terms of the appointment order. However, in order to obviate the arbitrary terminations, if any employee under the scheme got to be terminated on the ground of misconduct, a formality of opportunity should be given to the employee to know the nature of the misconduct, and considering his explanation, a summary inquiry can be held. However, a full-fledged inquiry contemplated in respect of civil servants need not apply in holding such inquiry. Only the spirit of principles of naturals has to be complied. In this case, there has been substantial compliance of principle of natural justice, and that petitioner has been notified the nature of misconduct, and considering his explanation and other reports, he has been arbitrarily terminated. There does not appear to be any arbitrariness or illegality of the part of the disciplinary authority. Accordingly, the petitioner was dismissed, my lord.
Where is the judgment? Who? This is a single judge's judgment.
Yes, my lord.
See,
That was
the
not
court
challenged.
says it is arbitrarily terminated and it is okay. Arbitrarily terminated. and
My
the
lord.
court find is okay, so
My lord, in this present case, my lord,
what is the ratio of this judgment?
ratio, my lord, that full-fledged departmental proceeding is not required for the contractual
All
employee.
right, but you have to hold an inquiry. That is the Supreme Court judgment. I'll follow that.
My
I'll
lord,
follow the Supreme Court judgment.
my lord, my next may be seen, my lord.
Hmm.
Number two judgment I have cited, my lord, 2019 6 SCC 250 250, my lord.
Hmm.
It says, my lord, it's to clause 16 of the agreement stipulated that in that case, my lord, in that their agreement, there is a clause. The first party will have the right to terminate the temporary appointment of the second party at any time without any notice. The services of the respondent were dispensed with on 21/3/2007. Challenging the order of termination, the respondent filed a writ petition which was allowed by the learned single judge of Rajasthan High Court on 6/4/16. The writ appeal was dismissed on 19/6/16. So and so, so and so. The sole ground on which the writ petition was allowed was that there was a breach of the principle of natural justice. The learned counsel appearing on behalf of the appellant submits that the High Court was in error, having regard to the fact that the nature of the appointment was purely contractual for a period of 1 year or until the shortage of waivers was made, whichever was earlier. Moreover, the contract stipulates that the services of the respondent could be dispensed with without any notice. We find merit in the submission. The termination of the appointment indicate that the respondent was only on a purely contractual appointment and that the service could be dispensed with without notice at any stage. This is a Supreme Court judgment, my lord.
Yes.
Now, I am not pressing the 3, my lord, judgment number 3. Lordship may kindly come to page judgment 4.
Hmm.
In this case, 1953 1 SCC 420. There was no compulsion on the petitioner to enter into the contract. He did. He was as free under the law as any other person to accept or to reject the offer which was made to him. Having accepted, he still has open to him all the rights and remedies available to other persons similarly situated to enforce any rights under his contract which have been denied to him. Assuming there are any and to pursue in the ordinary course of the land such remedies for a breach as are open to him to extremely the same extent as other persons similarly situated. He has not been discriminated against and he has not been denied the protection of any law which others similarly situated could claim. The remedy of a writ is misconceived. Article 16(1) is equally inapplicable. The whole matter rests in contract. When the petitioner's first contract came to an end, he was not a permanent government servant and the government was not bound either to re-employ him or to continue him in service. On the other hand, it was open to the government to make him the offer it did of a continuation of his employment on a temporary and contractual basis. Though the employment was continued, it was in point of fact and in the eye of law under a new and fresh contract which was quite separate and distinct from the old, even though many of its terms were the same. From this case, my lord, I want to submit, my lord, that all the employees of the Panchayat department, my lord, contractual employees, my lord, are treated like this, my lord. It's not a case, my lord, biasedly we are terminated these petitioners, my lord.
Who is saying that?
I'm just submitting that, my lord. That is before the accepting, signing the agreement, my lord, that there was open. They have read the agreements, my lord. Thereafter, they put it the sign, my lord. Therefore, I am submitting, my lord. There was no service rules.
Which says that if we feel that there is misconduct on your part, we can terminate your service without holding a proper inquiry. If that clause is there, then you can do it.
My lord,
Where is that clause?
termination clause. I am reading,
Yes,
my lord.
yes. Not 9. 9 has nothing to do. That I am rejecting right away. 9 has not been entered with.
There is a clause that if service is not satisfactory, I can, my lord. We can, my lord.
Misconduct and service not satisfactory are the same thing.
My lord, in this case, my lord, he admitted, my lord, that in the pressure of video, he put his signature and forwarded the same. Maybe for the department, it is not satisfactory.
Okay, move on next.
And all the charges were in the so-called notice. We have mentioned all the charges, my lord. He was given enough opportunity, my lord, to reply to the charges, but they have accepted that in the pressure of video.
And how have you dealt with his reply?
Reply.
Where is the finding of what?
My lord, my lord.
Show me the records. Where are
My
they?
lord, lordship may kindly see
Hmm.
the impugn order
In which page, which case? Case
in
number?
one, my lord. I'm reading from one.
All right, where is the order?
Page 65, my lord.
Hmm.
Detailed order is there.
So please read that part where the reply of the petitioner has been considered, dealt with and rejected with a reason.
My lord, I'm reading para 2, my lord.
Hmm.
Whereas a so-called notice was issued against Sri so-and-so, accredited engineer or Dakhin of so-and-so development block, Kasar, by letter number so-and-so, dated 17/6/22 on the basis of inquiry report. Whereas the delinquent official was submitted replies of so-called notice on 5/8/23 and the replies were not found to be satisfactory. Whereas the Sri Syed Masood Mazumdar, accredited engineer, during the time of hearing on 25 August, has admitted preparation of 53 numbers of schemes within a short period of 2 weeks that were not approved by the Gaon Sabha, violating 7.11.5 of the Master Circular, in which emphasized that incomplete ongoing works should be given priority in the allocation of work. Whereas the delinquent official has neglected to uphold the requirement of maintaining mandatory work files for each scheme, thereby violating 7.11.5 of the Master Circular 1819, which stipulates that a case record work files is a physical file that must be maintained for each project work under MNREGA. This clearly indicates a violation of both the provisions and the spirit of the Act. Failure to maintain demand register. The delinquent official did not maintain a demand register during the execution of the schemes, which is essential for taking laborers' demands and allocations. Whereas the delinquent official were found responsible for allocations work to job seekers as per para 4115 of the personnel guidelines of MNREGA, which states that the responsibilities of the accredited engineer are overseeing the process of registration, distribution of job cards, provisions of date-wise receipts against job applications, allocations of work to applicants, etc. Whereas accordingly to the operational guideline 2013 of MNREGA, it is extremely important that workers are assigned first to ongoing works so that this can be completed on time and the benefits thereof can be delivered. The delinquent officials initiated 45 numbers of new schemes out of 53 numbers of sanctions without the approval of the Gram Sabha and immediately began allocating works to job card holders in a single Gaon Panchayat after the schemes were sanctioned without considering ongoing works. This indicates a lack of proper planning and coordination and execution. Whereas, according to para 4114 of the operational guideline 13 of MNREGA A, recording attendance of laborers every day, either by the officials themselves or through the made in the prescribed master rules at the work site. B, ensuring that all mates attend work sites on time and take roll calls attendance in the prescribed master role at the work site only. However, the attendance of workers shown to have been taken at the work sites of a significant numbers under 45 new schemes started at the Gao Panchayat, which is not negotiable in work execution as per para 5B, which says master rolls will be maintained only work site with copies in the Gao Panchayat were not consistently recorded by the delinquent official, suggesting a lack of transparency in the employment process. Whereas the absence
Just
of
hold on, just hold on. So
Okay.
this part,
my lord,
just now you have read,
yes.
where is the allegation in the show cause on this part? Where is the allegation? on this?
54, my lord, so cause
Okay.
notice.
Yes. So show me the allegation that regarding this either by operational guidelines of 2013, recording of attendance, labor, etc. were not done. Where is the allegation?
May I read, my lord?
Yes.
In pursuance of the government letter dated 5/5/2021, an inquiry was conducted, and on perusal of the report dated 1/12/21, submitted by the Joint Commissioner and Assistant Commissioner of this Commissionerate relating to alleged anomalies in the preparation and execution of the list of schemes under MNREGA during 2020-21 under Sonai Development Block. Kachar in respect of WPC number 31121 in the matter of C. Taher Borbuya and WPC number 3976 2021 in the matter of Forana Begum Laskar. Copy enclosed. In the with the so-called notice, both the petitions copy were enclosed. Where the all
I'm
uses
asking you just now, you have read, no? Whereas
Yes, yes.
according to the operational guidelines of 2013 Menrega, it is extremely important workers assigned first to ongoing works, etc., etc. The delinquent official initiated 45 numbers of new scheme, so and so approval, then next paragraph.
Yes.
Next paragraph. According to para 4.1.5 of the operational guideline, recording attendance of labor every day either by etc. 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 So I am saying this is a finding,
My
is
lord.
it not? Where is the allegation?
My lord, first paragraph, last line, my lord,
Hmm.
wherein it has come to the notice of the understand that you have prepared the list of 53 numbers of INRM schemes without giving weightage to scheme approved by the GDPD
Mr.
and
Datta.
thus violating existing government guidelines.
Understand simple English.
My lord, yes.
Where is the allegation that you have not maintained the attendance of labor every day, etc.?
My
Where is
lord,
it?
for that, my lord, we have, my lord, the existing government guidelines. He is a skilled worker, my lord. He is a skilled worker. He is very much aware of the what is the guidelines are, my lord. My lord, lordship.
Please conclude now.
Yes, my lord. Now I am reading, my lord, 1962 SCC online, SC 115, the number 5 of my list of citations, my lord. Union Territory of Tripura versus Gopal Chandra Datta Chaudhary. Paragraph 4. We are unable to agree with the Judicial Commissioner that the termination of the employment of the respondent by the Superintendent of Police by order dated December 6, 1957 was in violation of Article 311(2) of the Constitution. It is true that before the respondent was discharged from service, no enquiry was made as to any alleged misconduct, nor was he given any opportunity of showing so cause against the proposed termination of employment. But it is well settled then when employment of a temporary public service is terminated pursuant to the terms of a contract, he is not entitled to the protection of Article 311(2). This is my main submission, my lord.
Yes.
That regular employee is not required, my lord, as Article 311(2) is also not applicable for the contractual employees. Para 6. A public servant cannot be dismissed or removed by an authority subordinate to that by which he was appointed, and that he cannot be dismissed or removed or reduced in rank until he has been given a reasonable opportunity of showing so cause against the action proposed to be taken in regard to him. In present case was so cause notice was issued, my lord, and he replied, my lord. Thereafter order was passed, reasoned order, my lord. These protections undoubtedly apply to temporary public servants as well as to public servants holding permanent employment. But the state is not prohibited by the constitution from serving a right by the terms of employment to terminate the services of public servant, and if in the bona fide enforcement of the right the employment is terminated, the protection of Article 311 of the Constitution will not avail him, because such a termination does not amount to dismissal or removal from service. So in the present case, no mala fide allegation of any against any officer, my lord. Therefore, my lord, this case is purely applicable in our case, my lord, and state has the right, my lord, to terminate the contractual employee as per contract agreement, my lord. And number 6 is lordship is very much aware. I was relaying Dansai case some causes.
Sir, judgment per incuriam and appeal is pending.
The lordship will deal with, my lord. My submissions I am just submitting, my lord. And I have just the number 7, my lord. This paragraph I was relying, my lord, for the wrong clause, my lord. In 2004-12 SCC 278, my lord, M money versus Sankita Therte, it's in clause the para 9, it's saying, my lord, it is well settled that if an authority has a power under the law merely because while exercising that power, the source of power is not specifically referred to, or a reference is made to a wrong provision of law, that by itself does not vitiate the exercise of power, so long as the power does exist and can be traced to a source of available in law. In that contract, my lord, maybe wrong clause was put in, my lord, but in that agreement, the termination of contract was there. That not vitiate the termination clause, my lord. Next, my lord, I am reading, my lord, number 8, my lord, 2011-15 SCC 16. This is Gridco Limited versus, my lord, and Sadananda Doloy, para 38. A conspicuous of the pronouncements of this court and the development of law over the past few decades does show that there has been a notable shift from the stated legal position settled in earlier decisions, that termination of a contractual employment in accordance with the terms of the contract was permissible, and the employee could claim no protection against such termination even when one of the contracting parties happened to be the state. Remedy for a breach of contractual conditions was also by way of civil action for damages compensation. With the development of law relating to judicial review of administrative actions, a writ court cannot now examine the validity of a termination order passed by the public authority. It is no longer open to the authority passing the order to argue that its action being in the realm of contract is not open to judicial review. A writ court is entitled to judicially review the action and determine whether there was any illegality, perversity, unreasonableness, unfairness, or irrationality that would vitiate the action, no matter the action is in the realm of contract. Having said that, we must add that judicial review cannot extend to the court acting as an appellate authority sitting in judgment over the decision. The court cannot sit in the armchair of the administrator to decide whether a more reasonable decision or course of action could have been taken in the circumstances. So long as the action taken by the authority is not shown to be vitiated by the infirmities referred to above, and so long as the action is not demonstrably in outrageous defiance of logic, the writ court would do well to respect the decision under challenge. This is one judgment, my lord. And next judgment, my lord, I am reading 2011-15
This
SCC.
judgment, Mr. Chaudhary is also relied upon.
Yes, my lord. Yes.
How does it help you?
My lord, if Malafide is not involved, my lord, court may not enter into a decision of administrative decision, my lord.
Hmm.
That is the issue. I'm relaying this paragraph, my lord.
Hmm.
Next, my lord, UP State Textile Corporation Limited versus Suresh Kumar.
Yes.
2011 15 SCC 180. Para 4. The learned counsel for the appellant has raised primarily two arguments before us. He has contended that the reference to the unauthorized absence of the respondent could not in any manner be said to be stigmatic and that the finding to the contrary was unsustainable. Alternatively, he has contended that the respondent had joined the service on 7/9/1987 for a period of 3 years, which would have come to an end on 6/9/1990, and as such, the direction for reinstatement could not have been granted to him. It has been placed that as a consequence of the order of the tribunal and of the High Court, the respondent has been put back into service. The learned counsel for the respondent has, however, supported the judgments of the tribunal and High Court. In the facts of the case, we need not examine the effect of the order dated 26/4/1989, whereby the services of the respondent had been terminated as being stigmatic or not, as we are of the opinion that in the light of the fact that appointment itself was for a fixed period of 3 years, which would have come to an end on 6/9/90, no relief beyond that period could have been given to the respondent by the tribunal or the High Court. We accordingly feel these orders need to be modified to extend that appellant shall be deemed to be in service up to 6/9/90 and not thereafter. My lord, it is admitted fact, my lord, the petitioners were working without, after expiring the contract, my lord. In the contract, it was said, my lord, they can, after fresh agreement only, they could.
So we gave you time on the last occasion. whether
Yes.
you want to withdraw these orders and then
We have
first,
already issued, my lord. Now we have already issued, my lord, for others, my lord, that who will renew their agreement, they will only continue. We already issued now that
but here the
thing,
subject matter is different.
my
The
lord.
challenge is-
In this by this
that
citation,
principle you cannot apply
yes,
here.
by this citation, I'm just submitting, my lord. Although court will find that something my lord. My lord, I want to just pointed out one thing, more thing, my lord. There are 3 types of termination of cases pending in these cases, my lord. Lordship had already dealt with 2 types, my lord. These are the 3 third types. First, my lord, employees were terminated with a serious allegations without giving any notice. The Surajit Burman cases are like that, my lord. Now, my lord, lordship has just a few months ago, my lordship has passed a series, my lord, that Pathapatim Saikia's case. These are second, my lord, that in our point of view, my lord, they were arrested. We have terminated without any serious allegation. We have just, that was a fact in our submission, my lord. That was a fact that they were arrested. We have terminated. And these are cases, my lord, where they were notice, service so-called notice was served. They have replied. Thereafter only we have terminated, my lord. For these cases, my lord, that is why I am submitting my humble submission is that substantial compliance of natural justice has already been done, my lord. Therefore, these cases are not permissible as per law, my lord. They are governed by contracts, my lord. There are no service rules against the contractual employees of the Panchayat and Rural Development Department, my lord. Therefore, these cases may be dismissed, my lord. That is my humble submission, my lord. Thank you for pleasant hearing, my lord.
Yes, what is your response? He says the show cause has been given, your clients have more or less accepted the
My
allegations.
lord,
So
yeah,
what purpose will be served, huh?
in my cases, my lord, I have not admitted to the fact. In respect to item 1 and 7, my lord, I think they have admitted. 2 to 6 days.
But they have tagged their matters, my lord, as a similar matters. That is why I have informed the court, my lord, before
So far,
starting.
allegations are concerned, your lordship, it puts a stigma upon the petitioner, your lordship, and so far as when the stigma is.
No,
there,
no, Mr. Datta is saying that you have admitted you have
no,
done all these things.
No.
Then why should there be another finding and inquiry? Inquiry and finding of facts.
But I have not given any opportunity of hearing, your lordship. In the order itself, it has been
What you
stated
have
that,
admitted, then where is the question of giving you an opportunity of hearing?
no, your lordship.
You say, yes, I have done it. Now you want them to again come up with an inquiry and prove that you have done it. That doesn't happen.
No, regarding that, your lordship, I have paragraph 10 of my reply, and I don't want. I have denied, your lordship. I have denied the charges level upon me, your lordship.
Where you have
That, sir,
denied.
I have been charged
Let us
against
see
me.
where you
It
have
has been
denied.
charged against me that I have done gross negligence in my duty and misappropriated government money with malafide intention is totally false and fabricated and baseless and concocted charges. I have discharged my duties with utmost care and sincerity and with entire satisfaction of my higher authority. Further, I obeyed all the orders of my superior authority being a subordinate, and I have no knowledge regarding the changes in the scheme list of the GPDP, and thus the question of violation of the existing government guidelines does not arise. And regarding the charges which has been leveled in the termination order, your lordship, in the show cause notice, these charges have not been leveled against your lordship. So against that charges, your lordship, I have not given any opportunity of hearing them. It's my view. And regarding this, submit one judgment, your lordship, regarding the where the honorable it is UP, for your lordship, it has been stated that the principle that emerges from the above judgment is patently clear that a show cause notice is required to provide the details of the nature of offences and the grounds on which the show cause notice has been issued. Furthermore, the order that is subsequently passed based on the show cause notice cannot go beyond the show cause notice and cannot in any manner penalize the noticee on the ground that were not stated in the show cause notice. Paragraph 10 also. Paragraph 9, your lordship, 9 and 10, please. Ten, your lordship, may I read you?
Hmm.
Paragraph 10 also, your
Hmm.
rationally for not allowing the respondent from going beyond the realm of the show cause notice that the
And where
petitioner
is item 7? Let us see where you have denied item 7. Last item. Where is your reply and denial? It's the same carbon copy of the other one.
It is on the basis of the same allegation, Your Lordship, and same. If the show cause notice was arises in pursuance of the order passed in WBC number 311, Your Lordship.
Yes, what else?
And Your Lordship, regarding the, I have also one, another,
Judgment on which point? What point?
regarding this, on principles of natural justice has to be followed and reasonable opportunity of hearing has to
That's
be.
already there. Mr. Chaudhary has already cited.
And I will rely on the submission made by engineer.
All right. That's all. Anything else? Huh?
My lord, as so far as my lord, his contention was that, my lord, that we have been terminated as our term of agreement was expired, my lord. But my lord, if we see the impugn orders, there is no such reference is made that due to expiry of our interim of our,
These contracts are valid till
for 1 year, my lord,
for 1 year.
for 1 year.
Then you have continued far
We
beyond
are
1 year.
allowed to continue and we were paid our remuneration, my lord, till the passing of this impugn order. And the impugn order, my lord, there is no such reference that since our,
Now, according to you, how long can you serve? Supposing the termination order is set aside,
yes, my lord,
you cannot continue till eternity.
yes, my lord.
How long can you serve?
My lord, we are serving, my lord, as they were allowed us to serve.
Hmm.
If after expiry of the 1 year, my lord, if they discontinue our service, then we have no such grievance, my lord. Before your lordships, my lord, they discontinue our service. they
So,
take
so
our
are you
misconduct.
saying that once the termination order is set aside, the respondents can be given an option either to hold an inquiry
Yes, ma'am.
or discontinue your service without any stigma? Either of the two options are available to them.
Yes, my lord, you opt for first, my lord, after an inquiry, my lord.
No, question of your opting
Yes.
doesn't arise. Question is, you are contractual employee.
Yes, ma'am.
The contract period is limited, specified. So it has far exceeded and you are saying they have allowed us to continue, we are continuing. But there is no written extension.
Yes, ma'am.
Now, we can find that this order is stigmatic because it has been issued without holding a proper inquiry. So we set aside. That order goes. But after that, there will be two options available to them, that if they want to terminate your service with an allegation of misconduct having been sustained, then they will have to hold an inquiry.
Yes, ma'am.
But if they do not want to hold an inquiry and do not want to press the charge of misconduct, then will it not be open for them to simply say that the contract is
Yes,
not renewed?
It is always open for them, my lord.
So that you are agreeable.
My lord, since my lord, the agreement, it was not extended and there is no allegation of
Allegation brought in, termination order mentions misconduct not preceded by a proper inquiry, violation of principle of natural justice. To that extent, understandable. So the court say, let the court accepts the argument and sets aside the order of termination.
yes, ma'am.
Then the next course of action would be to give them liberty that you now conduct a fresh inquiry against them and prove the charge. If you want to terminate them on the charge of misconduct,
Yes.
prove the charge. But if they say that, all right, we do not want to press the charge of misconduct against them, but we are entitled not to renew the contract, then can they not do it?
They can, my lord.
That you are agreeable.
They can, my lord.
No, you please be loud and clear.
They can, my lord.
Because nowadays, video recordings are
Yes,
later
yes,
on
sir.
shown in
In fact, they
appeal.
are watching, my lord.
Yes. So that you agree.
Yes, ma'am.
And do you have any legal submissions to make on that?
My lord, since my lord that at present this proceeding, my lord,
Hmm.
The subject matter of challenge is regarding misconduct, my lord.
Hmm.
So I want to,
So you are again going back to the same thing.
yes, ma'am.
So you don't have an answer for the second option. Is that correct?
Yes, ma'am.
Okay. Okay. Anything you want to add?
Other cases, Your Lordship, this
Uh-huh.
honorable court has directed to reinstate the petitioner and it is open to the department to proceed against him.
That's the question I'm asking you. Why is it that the second course of option should not be given to the department? Because you knew it was a contractual appointment. It was not a contract for eternity. We have to go by the law. So you knew that your service is for 1 year.
But
After
it
that, they may
extended
extend it, they may not extend it.
It extended time to time without any.
Well, show me the order of extension.
without
All
any-
right, order reserved. Don't waste the time of the court. If you don't have an answer, say that we don't have an answer. Heard Mr. K. N. Chaudhary, Learned Senior Counsel, listed by Mr. R. M. Decker, Learned Counsel appearing for the writ petitioners in item numbers 2 to 6. Also heard Mr. K. Mira, Learned Counsel for the writ petitioner in item numbers 1 and 7. Mr. S. Datta, Learned Standing Counsel, PNID Assam, has appeared for the department. Anybody else? You are appearing for all the respondents. PNRD department, whereas Ms. A. Talukdar, Learned Government Advocate Assam, has appeared for the state. Yes. Arguments concluded, judgment reserved. You can give me all this. Yes. It all.
Pending matter.
Yeah. Family.
Pending motion matter, item 17.
May it please your lordship may take up the matter tomorrow. We'll try to produce the relevant medical document.
He wants it to be taken up tomorrow. All right. On the request of petitioner's counsel, list this case again tomorrow for motion as a fixed item. By showing the name of Mr. B. Chakravarti, Learned CGC, for the respondents in the call list.
Obliged.
For hearing, I
Yeah, please, Your Lordship. Can this matter kindly be taken some other day?
On the request of petitioner's counsel, hearing of this matter stands adjourned for 4 weeks. Yes.
Obliged.
May I kindly fix the matter for at 2 p.m.
After 2 weeks, on the request of petitioner's counsel. Yes.
Your lordship, my senior is in lax. So sir, please fix the matter after the vacation.
On the joint prayer of learned counsel for both the sides, hearing of
12
this
and
matter
13.
stands
Is it 12
adjourned
and 13?
for 3 weeks. List again after the upcoming summer vacation. 12 and 13 same. Yes, 15. Item 15. None appears for the petitioner when the matter is called up. Ms. A. Talukdar and G. Assam, present for the state. If the petitioner's counsel is absent today, list this case for hearing again after the ensuing, after the summer vacation.